This just keeps getting worse.
Let me ask you a question.
Sure.
Why am I going to prison?
Why are you going to prison?
Breaking into my own apartment.
All right.
A lot of you have seen the clip where Cody Cross asks why he's going to prison, and Judge Boyd makes it clear that he's broken conditions and will likely do it again. If you want to watch a little bit about what led him to that moment, this video is for you. We put together some of the most recent hearings that will give you an idea of who Cody is, what he's done, and why a 5-year prison sentence is appropriate. To shorten this video, we edited out a lot of the legal conversation that Judge Boyd is required to go through with Cody and the lawyers.
All right. And count 4, you're charged with the offense of attempt to commit a burglary of a habitation. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes,
And counsel, is he applying for deferred adjudication as well or no?
He's applying for both. The state is opposed to the deferred and silent on the regular probation.
According to the plea, the state is proceeding on count 4. Punishment is to be assessed at a cap of 6 years in the prison. There's a $1,500 fine. The state is silent on your application for your community supervision. The state opposes your application for deferred adjudication. This is run concurrent with 2024 CC 742862. The state will take in consideration 2024 CC 742860, 2024 AL 004803, and there's to be no contact with the complainant. Did you understand that to be the plea?
Yes, ma'am, I did.
Defense is at the plea?
It is, Judge.
State is at the plea?
It is, Your
To
Honor.
the offense in count 4, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. State Exhibit 1 with attachment.
No objections, Judge.
All right, Mr. Cross, did you review the document entitled Waiver and Consent to Stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir. Yes, ma'am.
All right, again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, if you would like, I could set this for a PSI. It'll be 8 weeks, or if you would like to set it sooner and he could have any witnesses he want.
As a matter of fact, there is a witness that I intend to call. He has an advocate out there that's, I'd like to set it sooner. Do you want me to contact the advocate and then subsequently contact the court for the purposes of setting the PSI? Or?
I mean, if you want a PSI, then what I'll have to do is it's going to be an 8-week reset because the PSI is through probation. I have no authority to get it done any quicker because they have other people who are waiting for the PSI. Or if you all would like to waive PSI, I can reset it for about a week or 2 weeks. So you can have whatever witnesses you would want to be brought in. And then state from you, I would need the criminal history.
Well,
And if you would like to have the complainant come in, the complainant can come in.
can I clarify something, Judge?
Sure.
If that's the case, I don't even know if Mr. Cross qualifies for a PR bond in the interim, or if the court is inclined to give him a PR bond on this case. I didn't make any representations to him about the likelihood or even his eligibility for PR bond.
Okay.
But
I would have him interviewed for one, but I can tell you, based upon what these charges are, it's likely that you will not receive a PR bond because these are assaultive charges. And I know the state is only proceeding on one, but it's a violation of bond protective order. It is listed. Okay.
So why don't we waive the formal pre-sentence investigation so we can get Miss Ivy here and reset her for a week? And then if she grants you probation, you might be able to get out. Otherwise, you're going to be waiting 8 weeks, and then there's still no guarantee she's granted your probation in 8 weeks. So you want to waive the formal PSI and just do a sentencing from the bench without benefit of the investigation, come back in roughly a week, as the judge suggested, and I'll call Miss Ivy. Judge, I think what we want to do is is just proceed with the criminal history and presentation of witness.
So he decides to come back a week later. That's when we hear about his criminal history, which is extensive for a man under 25. And we hear testimony from a case manager who says if he can get probation, they'll be working together to stabilize his life.
Both parties agreed to waive the PSI. Is that correct, state?
Yes, Your Honor.
Defense, is that correct?
Yes, Your Honor.
All right, according to your plea bargain agreement, the state was proceeding on count 4 only. State waived count 1, 2, and 3 without objection. You waived the PSI. To count 4, you entered a plea of no contest. According to the plea bargain agreement, punishment is to be assessed at a cap of 6 years in the prison. There's a $1,500 fine. The state opposes your application for deferred adjudication. The state is silent on your application for community supervision. This is to run concurrent with 2024 CC 742862. The state is taking in consideration 2024 CC 742860, 2024 AL 004803, and there's to be no contact with the complainant.
That's not an issue now.
All right. So are there any witnesses, state you're opposed to his application for deferred adjudication?
Correct, yes, ma'am.
And why are you opposed to the application for deferred adjudication?
Given his criminal history, Your Honor, the defendant, even as a juvenile, has many assault cases, a lot of them involving the same victim. The cases that are being running concurrent and TIC'd as well include the same victim. So given the defendant's history for violent offenses, we are opposing his application for deferred adjudication.
All right. And what is his criminal history?
So in 2012, he had 3 juvenile ABI charges. In 2022, he had a burglary vehicle charge that he did 1 year of deferred adjudication on.
And did he successfully complete that?
Yes, Your Honor.
Okay.
He has one of the 2023 ABI cases that's currently pending that's part of this plea deal. The terroristic threat in 2024 that's currently pending as part of the plea deal as well. Another 2024 ABI that's pending as part of this plea deal. And he's got some out-of-state charges from Oklahoma for DUI and possession of a controlled substance that are currently still pending in that state.
All right. All right. Any witnesses state with regards to your opposition to deferred adjudication?
No, Your Honor.
All right. Defense, any witnesses?
Judge, I'd like to call Ivy Regalado. She's present today for about 5 or 10 minutes of testimony.
Sure, sir. Excuse me, Mr. Cross. Will you step over there, please? Right. Defense?
Ms. Regalado, do you know Cody Cross?
Yes, I do.
And how do you know him?
I work for Sam Ministries as a rapid housing case manager, and he is one of my clients.
And so is it fair to say that Mr. Cross was seeking housing through your entity?
Yes, Cody Cross is on my youth program, and he was homeless, and we have been working together to stabilize him financially, education-wise, and housing-wise.
And what's your understanding of his housing situation right now?
Right now, if he was able to get probation, I would still be able to house him. Because of his age, he is priority on the housing list, because he is under the age of 25. If he did serve more time and did not get out until he was 25, the chances of him getting housing with any kind of assistance is dramatically reduced.
Okay, and what is his history that you learned during the process of trying to get him housing?
Cody has extensive childhood trauma that has been unresolved. I have been working with him to get into counseling and to take anger management classes. I do understand that he has been in and out of the system for a very long time. But working with him and learning more about him, I do believe that he's not given a fair chance and has not been given a fair chance. And I would like to continue working with him to get him out.
Okay, and when you say he's been in and out of the system, are you talking about as a CPS foster child?
Correct, yes.
Okay. And did he qualify for housing before his extended incarceration pursuant to the pending charges? Did he qualify?
Yes,
And your testimony then is that he still qualifies, should he be able to get out?
yes. If he was able to get out, he could continue on my caseload for almost another 2 years, which would help him go to therapy free of charge, get housing free of charge. He could go back and get his GED and pursue further education, also free of charge with working with our organization.
And did he indicate a willingness and desire to participate in your organization except for purposes of the housing?
Yes, he did.
Okay, and then does Mr. Kraus have a CPS case wherein he's a parent right now?
Yes, he does.
And he does he have obligations under a service plan that he needs to complete in order to maintain his parental rights?
Yes, he does.
Okay, would he be able to do that if he was incarcerated?
I know. He did not.
Judge, I'll pass the witness.
All right, any questions?
Just a few questions. Morning, ma'am.
Good morning.
Now, you testified earlier about your interaction with the defendant, Mr. Cody Cross. Could you please testify again as far as when you first came into contact with him?
I believe it was April of last year, so I've been working with him almost a year, and he was referred to me by my supervisor.
Okay, almost 1 year of contact with you.
Yes.
Were you aware of any of his history prior to that time?
We have some case notes when we get the referral, but most of it is just one-on-one conversations with him.
Okay. Were you aware of any of his criminal history at all?
Yes.
Okay. And does his criminal history play any type of role or decision making into his applicability for housing?
Absolutely not.
Okay. You mentioned that you have, or that he's going through counseling, is that correct?
Yes.
Okay, what kind of counseling is he going through?
So we had put in the referral right before he got arrested to do counseling and psychotherapy. And this can be done virtual or in person
Okay.
with UT Health.
Has he been in compliance with his counseling?
He has not been able to because he's been incarcerated. I will just say that the referral was voluntary. It's not mandated to stay part of the program. He chose to do that by himself.
Now, are you aware that even after you come into contact with him in April, that he's committing crimes in September?
Yes, I am.
So despite that, that's again not playing a part in your decision for housing on him, correct?
Correct. So when he was released, when he went back home, the apartment that we had worked together for him to establish was only in his name.
Okay.
I understand that there was a violation where he was not supposed to get in contact with her, with the defendant. But that housing was just for Cody. I'm not making excuses. I'm just offering an explanation. The other person was not supposed to be in the household. But we were working on, because she would not leave, we were working on getting him rehoused somewhere where she did not know the address to, so that way they would not have contact.
Yep.
And so if he was released on probation, we can immediately house him somewhere else to where, again, there would be no contact with that home.
No further questions, Ryan.
Any further questions?
Pass the witness, Judge.
All right, I have a few questions. So when did you start working with him? What's the month and year?
April 2024.
All right. And when you began working with him, was he already in this relationship?
They were on, yes.
All right, and were you aware of that?
Yes.
And when you were working with him, was there any work done related to any relationship issues he had with the complainant?
We had done the housing separate from her, just because they were having some issues. Cody had decided just to get the apartment by himself, so that way she would have, his housing could be stable. When that happened, a couple months later, if that, she had stated that she had nowhere to go with their children, so he let her into the apartment. But she was never on the lease, And we were just trying to work it out through going to therapy to see if they were going to work it out or if they were going to if she was gonna leave.
All right. And then, do you remember what month or of when she moved back in or when she moved in?
May, June, I'm not too certain.
All right. And did you ever do any therapy inside the home?
Me,
Yes, or anyone else?
so we do, at least bi-weekly visits. And so I would go in, we would talk about his goals. She, even though she wasn't my client, she was able to be part of the goals because she was on the housing. But I just worked mainly with him because she didn't really want to do anything. So we did like biopsychosocial assessments, mental health assessments, just to see where he was at mental health wise. And I gave him resources like the UT Health partnership that we have. And he decided to take advantage of that, a little bit too late, but he did volunteer to put in that referral.
All right. So you just said something about housing. So she's on housing, is that correct? But she's not supposed to be in that house.
So the way that our program works is we have one client. So he was the one that got pulled for housing. If the kids come or a spouse come, then they're automatically able to get resources from us, but he would be the main client. So if she chooses not to do any services like the GED or employment, then that's something that's just out of my control. And I would really just focus with him because he's the main one.
Okay. And what type of services are you offering him now if he were placed on probation?
And so if he were placed on probation, immediately we would try to house him. The goal is always under 30 days, but we can make that happen in 24 to 48 hours with the landlords that we work with. And from there, we make a housing goal. So if he wants to go back for his GED, we can set him up with that. We also partner with Goodwill to get him employed, work on a resume, work around his criminal background. And we also work with UT Health for the counseling. Sorry, I'm blanking. But we have resources for everything, and the goal is after the year to 2 years, you can be in a place where you can get mental health help, you can get physical help. So we can help them with SNAP benefits, we can help them get Medicaid so we can go to the doctor.
So does he have mental health issues?
I would say yes.
Does he have any drug issues?
Prior, yes.
And prior, what was that?
From my understanding, just weed, not just weed. But I was never, nothing else from my understanding.
All right. If the court were to grant him probation as a part of his housing, could you ensure the court that you would not allow other persons to stay in that house?
Yes, I can. We work with the landlord. If the landlord sees somebody or if I see somebody, because we can just be dropping visits, we can talk to him about it. We can talk to the court about it, which I'm assuming there would be something in place. But from the conversations that we've had since getting arrested, because we've had a couple, I do think that he genuinely understands the severity of, while you were in that mindset of trying to do the right thing for the right reasons, look at where it's landed you. And I do understand that. I do think that he understands the severity of this cannot happen again.
All right. So here's the problem. I've just been informed by the state that he has out of county issues as well, and they're still open. So how is that addressed? Because he has out of county cases as well.
I can talk to my supervisor. I know we have worked with out of county. I haven't had that experience with a client, but I do know that we've worked with other courts to resolve that so they can keep their housing.
All right. And if the court were to send him to prison, would you all still be able to work with him when he was released?
No, he would have to get back on the waiting list. But again, there's priority given to ages 18 to 24, just because so many have just aged out of foster care. That's my grant. So he would have to just go to the general one, which is about a 5 to 7 year waiting list right now. And so he would not be eligible just to get back on the services because he would age out from the program.
All right. And so how long do you have this placement open for him?
Right now, we're just waiting for a decision from you. But we can, if he was released, we could keep him up to almost a year and a half now, from now. Because he was only technically housed for about 5 to 6 months, and we can keep him open for 24 months.
All right, so here's the problem. I don't know what's going on with his out-of-county cases. I don't know if he has a warrant for that or not. So he may not be released. So I'm just trying to find out if I were to grant him probation and he's not released from the other county, if they pick him up, how long would the opening last for him? Because if I were to grant him probation, once he's released from custody, I would want him immediately in the program. So is that possible?
Yes, so as long as we know that there's updates, as long as we have updates, so even me coming here today, that's something that I can place note that he's still my client and we can keep him open. And that doesn't go towards the year and a half. So as long as we know where he's at, what's happening and there's updates, then we can keep him open so that the day he's released, he has somewhere to go.
All right. Thank you so much for coming down.
Thank you, John.
Oh, I'm sorry. Any other questions?
No, Your Honor, thank you.
Maybe just one question more, if that's
Sure.
okay. You mentioned earlier that in your opinion, you feel he's got mental health issues. Is that correct? And have you had any training or experience being a mental health professional?
So I have trauma informed, I have my trauma informed care certificate. We do extensive training with childhood issues, with ACEs, we do biopsychosocials. And then from there, we take it to a professional. But I think anybody with that kind of childhood knows kind of issues.
I understand. But have you ever made a mental health diagnosis yourself?
No.
Okay. No further questions, Your Honor.
All right. Is there anything else?
I just wanted to call Mr. Cross for a second, Judge.
All right. Thank you. All right. So before you call him as a witness, I don't know, he may say something that will make me make up my mind, or he may not. But what I'm going to tell both parties, there are two things that I need to know before I can make a ruling on whether or not to send him to prison or whether or not to place him on probation. Two things I need to know. Somebody needs to contact whoever his attorney is out of county to find out what level those DWIs are and exactly what is going to be happening with that. Because if they are, sending him to jail, if it's a misdemeanor, or sending him to prison, then all of this is for naught. So I need that. And if somebody wants to call the complainant as a witness and have them zoom in, that would be appreciated.
Apparently, we have reached out to the complainant and she's not getting back advice, so I don't know that that's going to be possible for the state's end.
All right. So counsel, how long will it take you to find out who his attorney is and what is happening with the misdemeanor cases or felony cases that are in that other county?
Well, that's largely dependent on the quality of information that the state can give me so I can begin my search. I'm not
Let me help
aware
you
of
with that.
these.
Come forward, sir. Come forward.
Yes.
What county are your other cases out of?
It's Oklahoma City. They had, when I first.
No. Listen to my questions. What county are your cases out of?
Durant, Oklahoma.
All right. Do you know your case number?
No.
Do you know who your attorney is there? All right, so we're off the record. This is the court's suggestion that you call Oklahoma, the county that he's out of, get in touch with the public defender's office, because I think they have a public defender there, and find out what is happening with his cases.
Next, he comes back for sentencing. And as Cody shares more information with Judge Boyd, it becomes more apparent that he's going to jail.
Rose, at the last date that the court was ready to sentence Mr. Cross was, you had asked me to contact the Durant County, Oklahoma clerk for purposes of trying to find out what was going on up there, and I have some information for the court.
Oh, yes.
So, Your Honor, he's got a one case number with 2 misdemeanor charges in Durant County, Oklahoma. The pending charges up there are driving under the influence of dangerous drugs and possession of dangerous drugs. So again, apparently the way they do it up there is one case number, but two counts, so to speak. And so going further in my conversation with the clerk, again, I know this is hearsay, but having heard no objection, I wanted to tell you that what the clerk represents is that, like Texas, she doesn't know if they're going to place a hold on him here and come and get him within 10 days. So I can't make any representations to the court in that regard. If they, just based on my experience for misdemeanors, I generally speaking, I'd find it unusual for one state to go pick up another. But again, that's kind of anecdotal, and I know you know as well as anyone what the likelihood of that is. But in any case, Judge, we're asking that the court grant Mr. Cross deferred adjudication. And I know that probation has also been applied for and that the state is neutral on our application for probation, but it's our position that if you give him regular probation, then he'll be somewhat hamstrung in terms of his ability to obtain gainful employment because he'll have a felony conviction. So with all due respect, we'd ask that if he has a chance at some sort of community supervision, that it be deferred so he's not addled with the felony conviction if he goes forth and tries to succeed. And just as a reminder for the court, we had a witness named Ms. Regalado, who's here again today, that testified about his time in the foster care system and stuff like that. So he's had a rough go of it. And then finally, I'd ask the court to take notice that his actions have not been without consequence. He's done a lot of days in jail. And so again, we're asking the court to grant him deferred adjudication at this time.
All right, and the court remembers the previous testimony. And correct me if I'm wrong, if my memory is wrong, but I believe the witness testified that the complainant was not supposed to be on the housing. It was just the defendant, and the defendant allowed or requested that the complainant be under his housing so that she and her children would have a place to stay. Is that correct?
Maybe misremembering, but I think it's something along those lines.
All right. All right. So this is what the court is wrestling with. But for the fact that this was his housing and the complainant technically was not supposed to be living under his housing voucher, but he took her in because she had children. If that issue wasn't there, you'd be going to prison. It would not be any type of constraint for me as far as sending you to prison. But I have to sort of weigh that. But then on the other hand, I'm weighing it with what I'm reading in the police report. That's an issue for me. Because what I'm reading in the police report is she called saying that you were in violation of your bond and were attempting to break down her door, which is your residence, and that you were just placed in jail for the same thing. And you had the no contact order in place, but you still went over there. So I don't know if you want to address that. And you're telling the officers, it's just a misdemeanor. So do you want to address that for the court? I mean, if you don't have to. I mean, you waived your right to remain silent by entering into this plea. But if you don't want to address it, you don't have to. But that's my concern. My concern is that you knew you were not supposed to be there. You were just released from jail. And it states, upon my arrival, and this is the police, I identified suspect 1 by asking his name, to which matched the key card, and I placed suspect in handcuffs. Suspect stated he just got out of jail at approximately 1 a.m. and arrived at the location on bus because he just wanted a place to sleep. Suspect stated that the listed location was his home and that he did not know he had a protective order. Suspect, however, contradicted himself by stating he made contact with the witness 1, that's Jasmine, through the phone, asking witness 1 to leave. I explained to suspect that he was not allowed to have any contact with witness 1. Suspect stated he did know he had no contact order with witness 1 while in the back seat of my patrol car. They patted you down for weapons. And while in the back of the patrol car, I gave commands for suspect to move his feet inside the patrol car, which suspect became non-compliant. I informed suspect it would be in his best interest to comply, so he would not catch an additional charge for resisting arrest. Resisting arrest, search, and transportation. Suspect stated it's just a misdemeanor. And then you proceeded to kick the car door. And then the other problem is, witness stated officers were at the listed location earlier this morning. Witness stated that during that incident, she reported the suspect calling her, threatening to harm her, and suspect stated he was going to show up to the above listed residence. And so there's a police report for that. And then it says you showed up at the above listed residence at approximately 5:55 hours by transportation of the via bus to the residence. Witness then stated prior to Officer Watts and my arrival, suspect was attempting to enter the residence by kicking the door with his foot and hitting the door with a rock. I observed what were shoe marks located on the door near the lower side of the door handle. Witness also stated suspect threw a rock at the door and attempted to throw it at the apartment balcony door, where I observed the rock located on the apartment balcony. So, do you want to say anything?
Your Honor,
You want to raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
so,
All right, and then it says, suspect stated that when he showed up to the residence, he was going to kick witness 2, Christopher Nunn, in the head and stomp on his chest. Suspect then made threats to witness 3, Dylan Moore, stating he was going to catch him and beat him up. All right, what would you like to say?
so with that being said, I know what the paperwork says, Your Honor, and, please.
I'm sorry, you need to speak up. I can't hear you.
I know what the paperwork said, and I understand that's, that was who I am, who I was. In these last 5.5 months that I've been incarcerated, I've learned my lesson. I have time to sit down and think. Me and Jasmine have kids together, which are currently in foster care right now.
No,
I
they,
understand it.
no, when you say you all have children together that are currently in foster care, your witness testified at the previous hearing that Jasmine needed a place for her and her children to stay. Usually when people say her children, that means that they're not your biological children.
They're my biological children.
They are your biological children? Okay.
I don't know why she said it was like that, but they're my children. Xavier Krause and Emery Krause. I just had a baby girl.
All right, that changes things for the court then, because I thought this was a complainant who just needed a place to stay with her children. That's the way the testimony was given to me, that they were not your biological children.
It's the mother of my children.
Okay.
We've been together for it would have been 5 years last year in November.
All right, so that means that she should have been under the housing then.
She wasn't under the housing, when she made the statement, calling and, she wasn't there for the first 2 months that I was supposed to get a 2-bedroom, 2-bath, was because I found a week before I got housing, I found out my baby mama was cheating on me.
You mean the mother of your children?
Mother of my children, she was cheating on me. So we broke things off and I went off and got the apartment by myself. I eventually got over it and I forgave her within that 1 month and a half. And I had asked her to come back home because she had my kids out in College Station. And the only reason why I allowed her to come back was because I wanted to be with my kids. My kids are everything to me. They're the reason why I'm not in prison as right now. Because, Your Honor, I should be in prison for a lot more worse things, but I'm not. And because of my children, they have made me to the person I am today. I would, I would really like the probation because I really have learned my lesson, Your Honor. I really have. This is a very long 5.5 months that I've been incarcerated, and I really, really, really know that I'm not supposed to contact Jasmine, and that won't be an issue.
How long were you in custody before you went to the home trying to kick the door in?
8 days, exact.
Okay.
And I was still furious because I know for a fact only me and God would know that I didn't do anything to that girl, but come home that night from St. Louis from my dad's.
So did you threaten her on the phone?
No, I did not threaten her.
So you stipulated to it.
I threatened Dylan because I told him that he's gonna have to, at that time, he was gonna have to fight with me because he went and asked, because I was allowing him to stay with me. Granted that I have housing that none of them are supposed to be there with me, but I'm risking my house to help others, you know what I'm saying, help him. And he went.
It's a sad situation that you're allowing random people to stay in a house and you have young children.
And it wasn't a random person. It was Mr. Christopher, her brother, his family friend. It was somebody that basically his brother. I never threatened Christopher at all. I actually have him.
No, it's as though no one's looking out for the children. You have a 2-bedroom apartment that the taxpayers are helping
No,
you
one
secure. Well, a 1-bedroom apartment that you're having taxpayers help you with. And you have the mother of your children in there. How many children do you have? You have 2 children. You have yourself. I'm assuming there's 1 bathroom. And now you're bringing in random people that the taxpayers didn't agree to pay for.
Your Honor, I have a huge heart.
No,
I
because
really
here's
do.
the thing. I don't understand why people get free things through the taxpayers because we're paying for it. And then your free heart is really not free. You're giving what somebody has given to you and paid for, and you're acting as though, it's your money when it's not. When you have these funded places that are funded by the taxpayers, you're not supposed to have everybody living with you. This Dylan person who you're saying is a friend of the mother of your children, you really don't know anything about him. And you're letting him stay in here, this random guy, be around your children. That's not a good parent.
We didn't. At the time he was living with us, we didn't have the children.
Oh, where were the children?
With a family friend because we were dealing with a CPS case.
This just keeps getting worse. Any questions?
Just a brief question, Judge. So are you right now obligated to perform a CPS service plan? Do you have obligations to CPS so that you can try to maintain your parental rights?
Case right now, the CPS caseworker comes and sees me every month.
Okay. And is that another reason you're asking Judge Boyd to consider probation so that you can perform your service plan?
Mhm.
Okay. Pass the witness, Judge.
And where are the children?
The children are with the family friend that was that they've been in custody with for the past 5 months.
All right. And when you went to go kick down this door or attempted to kick down this door, were the children in?
No, ma'am.
So CPS was already involved. All right. This is what the court is going to do. Court is finding you guilty. This will run concurrent with 2024 CC 742862. Take in consideration 2024 CC 742860, 2024 AL 004803. There should be no contact with Jasmine Nunn, N-U-N-N. And the court will sentence you to 5 years in the prison, give you credit for any time served, and I'll request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Your Honor, may I ask you a question?
Sure.
Why am I going to prison?
Why are you going to prison?
Breaking into my own apartment.
All right, let me explain something to you, and I'm sure your attorney explained it to you. When you have a protective order, in that protective order, it tells you what you're not allowed to do. Usually in a protective order, it will tell you there are certain locations you can't go to. There are certain people you can't be around. I'm sure in your protective order, it states that you were not allowed to be around Jasmine Nunn. You did it anyway. I'm sure in the protective order, it told you were not to go to that location. You did it anyway. That's a court order. When you violate court orders, that's a signal to the court that you're probably not going to abide by conditions of probation. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Counsel, did you go over the trial court certification of defendant's rights to appeal with your attorney?
I did, Judge.
And did he sign that?
He did.
All right, thank you.
Judge, will the court retain jurisdiction for purposes of consideration of short probation?
Sure.